Okay.
Yeah, but exactly.
Uh,
I mean, that's insane.
Well, you know, I think this is still a work in progress. Let me say, while really applauding the idea, I have to say that what's I'm very reluctant to deny the unsophisticated defendant the ability to have someone advise them on the consequences of making the decision to an infraction, unless we're sure that we have not done anything that's going to trigger unintended consequences. I mean, a statement was made that I think I heard, which is that they will still have a right to attorney, but not at the taxpayer's expense. I'm sorry, many of the people who have misdemeanors and infractions need an attorney at the taxpayer's expense. That's why we have public defenders. And it would seem to me there could be some kind of an arrangement where there's a public defender who does this, who if it's not going to be in writing, explains to people that there could be, under certain circumstances, the following consequences. What do you want to do? I, am wondering if the author and the sponsor have a suggestion for an amendment to the bill that would allow counsel for people in making this decision. That is one thing. I also feel that we should retain the current ability of a judge to make this decision. So we would be adding to the ability to move a misdemeanor to an infraction, as opposed to taking it from one branch of government to another. But I do, I wish we knew more about the potential consequences of having a misdemeanor and an infraction, because if they're as rare as you're indicating, what could we do to trigger somebody actually having the right to counsel in that? I guess in the real world, I'm also concerned, and I would like everybody's opinion on this, because I'm sure you've thought about it, about this somehow adding to the inequality in law enforcement and corrections that we see, which is the racial imbalance. In other words, a white middle-class person comes in, they had a little hit and run, we don't want something on their record, so it's an infraction. Poor person of non-Caucasian person comes in, and, well, there could be a problem. Let's keep it a misdemeanor. We've noticed the racial disparities. They're discussed across the state right now. What do you think is the potential for increasing that concern, which isn't just ours, it's the entire community? Again, I welcome anybody's comment.
I'm not sure that this bill, as it's intended to work, would increase racial disparities. I would hope that it would reduce maybe some of the racial disparities. For example, just in my particular time as a misdemeanor deputy, a lot of those infractions or misdemeanors that I reduced to infractions were actually based on the economic realities of that particular defendant. And I don't know, but I know most of the time it was the defendants that benefited from that were not Caucasian defendants. But I think you, as Senator Leno had indicated, in different parts of the state, different prosecutors will choose to use the tools differently. Los Angeles, Alameda, San Francisco are a little more progressive than other parts of the state. Yeah, you have very conservative areas in parts of the Central Valley, in the northern parts of the state, parts of the Inland Empire. Yeah, the DAs there, may or may not choose to use these tools. I will say that, the Inland Empire is probably one of the more conservative areas of the state. And I know the new district attorney in Riverside County and District Attorney Ramos in San Bernardino County actually have taken advantage of some of the changes that have gone into effect, and I think in utilizing them in ways that are much better than even some of the more progressive counties. But it's kind of it's one of the tools in a DA's tool chest that they're going to use, and different counties are going to use it differently. However, to the extent that we would create some category of misdemeanors that can be reduced to an infraction, expanding that, the potential number of wobblets isn't really a bad thing, because there are, misdemeanors that in reality today get adjudicated in ways that don't involve misdemeanor punishments. I would imagine a lot of the, like the homeless camping, I would be shocked, even in Sacramento, this is very conservative, if the DA is, and the sheriff are incarcerating homeless people for illegal camping. In our county, my DA is doing everything she can to create what would be the largest mental health diversion program in the country. So a lot of the defendants that I would anticipate that could benefit from this would, in our county, maybe benefiting from a different program. But I think that overall, if this bill is, tightened up and everybody's, getting involved, I think it would be a good thing, and would help, reduce the negative consequences of the criminal justice system for a lot of defendants.
And you're opposed to the bill?
I'm opposed. We're opposed to the bill for technical reasons.
I understand.
We share the goal. I want to
We
make
all
that
share
clear.
the goal, I think. The question is how you get there without the unintended consequences
Correct.
in a way that's responsible.
Madam Chair?
And
Yeah,
that's-
right. When-
Please, yeah, go ahead.
Well, I was just going to say, right now,
Okay, we're going to have to keep order here. That's going to be,
right now, the chair, you talk about, retaining the judge's discretion. Right now, that discretion only applies to the list of wobblets on 19.8. So if this bill goes through, it, depending on how it's drafted, you can either give
Add
the
to the
judge's discretion to the 19.8 or go as San Diego is proposing to create kind of like a 19.9 that would not have that discretion. I know the code section, but, so, yeah, it's a choice for the legislature.
okay.
I do believe, in response to your question, that there may be some unequal benefit granted to certain individuals based on their background. I think that the charging decisions will likely reflect how charging decisions and prosecuting decisions are currently made. So I don't see a huge expansion since these are all charges of misdemeanors now. Our bigger concern, frankly, would be that somebody who is not aware, again, of the consequence or the cost of their infraction would be regularly choosing this particular way of being charged as an infraction, and that what we would end up having is, a lot of people who don't have the knowledge of the criminal justice system being targeted for the infraction because of the fact that they can't ask for counsel, because of the fact that it's guaranteed resources coming in and very few resources going out, and that this, in some counties, may be used as a way to just, ensure that people are writing checks, which will mean not only that the misdemeanor will be, not only that they'll be charged as infractions, but that because they can be charged as an infraction, the decision to actually go after, charge, and prosecute individuals may be expanded because of this kind of low bar for collecting the fees, which are going to be lower here. So that's one concern that we have.
Madam Chair? So,
Senator Leno.
thank you for your patience. I do have a few more questions, and for many of these misdemeanors that we're talking about here, this universe of misdemeanors, if I do choose the path of counsel with the potentiality of being convicted of a misdemeanor, my punishment could likely be the 6 months in county jail. Is there also likely to be a fine with that? So that 250 is still going to be there, or 100, whatever it might be, 100, 250. Plus, I'm going to potentially go to county jail. So I don't know that there's greater incentive one way or the other. I guess in the one way, well, this is where the prosecution gets to determine how strong their case is. Right. If they know that they may not win the prosecution of the misdemeanor, then they're going to come up empty-handed. They've expended certain resources to get nothing. So I can understand that this way they're going to get their 250 without any effort. On the other hand, if I know what I've been charged with, and I'm happy to hear from either of you, these are not complex cases. For example, if it is petty theft, I know I took it or I know I didn't. And if I know I took it, then maybe I don't want to, I should just pay my fine because I don't want the misdemeanor. On the other hand, if we do have a disadvantaged person, discussed as unsophisticated in the court system, who knows that he or she is in fact innocent, for any number of reasons may want to have their day in court. And then they are going to get counsel. With regard to the concern for racial disparity, I didn't see the concern there because, and not to deny that there's enormous disparity, and it's not just based on race, but it's also based on poverty. A lot of injustice. But if there is a inherent bias in prosecutorial charging, then there, on the misdemeanor side, then there will be counsel anyway. So I don't know that we're putting anyone at any greater jeopardy than they're currently. Might we consider, because I don't want to lose, and we're giving this a really good scrubbing, and this is important. I appreciate the time you're affording us, Madam Chair. But I don't want to overlook the good that I think this can provide us. We know we've cut $1 billion from the courts. The savings could be in the hundreds of millions of dollars here, the difference between the $500 million they're paying now and the 1/10 of what it's going to cost. So there could be upwards of approaching $500 million in savings, not insignificant, that we wouldn't have to put forward out of our own general fund. Again, always with concern for any unintended consequences and injustice. Might we consider putting a sunset on this of 2 or 3 years and have folks come back and say, did our worst fears materialize or did they not? Because it is something new, and we might, I think the legislature should keep an eye on it if we are in fact going to go forward with it. So I think with the exemption of any corporate crimes, some sort of sunset, and if you've got the wherewithal for it, I don't know that I know what Section 19.8 is and where the judicial discretion exists in current law that with the wobblets that wouldn't exist in this expansion of wobblets. That notwithstanding, I think I could be prepared to support it.
How do you feel about retaining the existing judicial discretion?
If you could better explain that to me, what existing judicial discretion there is.
I think what the chair is talking about is in Penal Code Section 19.8, there is judicial discretion.
Where does that occur?
The court, with the consent of the defendant, determines that the offense is an infraction. We want to retain the ability of the court, with the consent of the defense, to do that.
So
Yeah,
that
to
is for
add
certain
that to the
wobblets
new-
right now.
The way the current law is with just those crimes that are defined in 19.8, it refers you to Section 17D, Penal Code Section 17D. And in 17D, it gives two options. The prosecuting agency can file it as a as an infraction, and the other option is that the court, with the consent of the defendant, can elect to proceed as a misdemeanor. So that's the judicial discretion part. In the
So
research,
the court, with the agreement of the defendant, can overrule what the prosecutor had.
can overrule the prosecutor filing it as an infraction.
Right, that
Correct.
is existing law. And
Yes.
and how long is that list and what's on that list? What wobblets are these that we're talking about?
Yeah, actually, yeah, just to correct, there was a misspeak.
Okay,
It's, the court determines that what was filed as a misdemeanor is in fact an infraction. You said use the word infraction twice.
Okay.
Okay.
Apologize.
If a person is charged with a misdemeanor, they are entitled to public counsel before whatever they
Right.
accept. So if this were added in, I mean, what I'm trying to do is make sure that I think it was Senator Monning's language, and it's good language, an unsophisticated defendant has some advice before they jump in any direction. And that would mean you'd save a little less money, but if it was then charged as an infraction and everybody agreed, we'd save all the money. That makes sense.
and what is the resistance of the San Diego District Attorney to the chair's suggestion here?
I think, and it was a situation that was referenced earlier, is in certain cases, is that we are not offering, or we are not in support of creating a way for the court to reduce to an infraction something that we file as a misdemeanor.
But that is current law.
No.
It is current.
That's current law only for a different set of offenses. It is not current law for the set of offenses that we're discussing today. It is not current
For
law.
the 3,000 misdemeanors minus the ones we just exempted.
Current law does not give judicial discretion on these offenses.
So, yeah, and you don't want to put this protection in your bill.
The DAs don't want to give away their power to charge as they see fit for the offenses we're discussing today.
Which they have now, and they don't.
That's
right.
correct. It's no
So
change from
Your
current law.
suggestion would actually expand judicial discretion beyond what exists now. So I get that. Madam Chair, with the idea of a sunset, I know you and I won't be here to review it, but nonetheless, it's not all about us.
Right? No, I agree. I think the idea of a sunset is a very good idea. What I'm honestly grappling with right now, this maybe should have gone to the Committee on the Judiciary. The fine tuning of court process, of charging, of the potential consequences. So we're trying to figure it out kind of on our feet
Yep.
here. And we're coming from a place where we really do support the expansion of opportunities not to become incarcerated.
Madam Chair, if I may, I mean, we've said, several of us have said, we all support the goal of this legislation. And it's important we not lose the forest for the trees here. The goal is what's important. Saving dollars is important because it will allow us to prosecute those who commit more heinous crimes and the kind of things we're talking about. Decriminalization, to me, is the most important goal, to keep homeless folks and others out of the criminal justice system for very minor offenses. Exempting corporations is fine. The author would gladly accept that amendment. Sunset, I would suggest about a 5-year sunset because we're told this will take a couple of years to incorporate into the process. So it would give us a couple of years then to see. if it's working effectively. So a 5-year sunset, an exemption of corporations, corporate defendants from this option.
Or maybe it would be Cal OSHA offenses, environmental offenses, that kind of thing.
Okay.
Because you might have single-person operators here, but
We can work on that, and both witnesses in opposition have agreed that we're working cooperatively, and we will continue to do so as we move toward the assembly. But we will agree to those 2 amendments if that will move the
Madam
bill
Chair,
along.
I might suggest, if we're going in this direction, if there is to be a sunset, and if it is to be as far out as 5 years, might there be some reporting back to this
I was
committee
going to
in the
say-
meantime?
with the collection of agreed-upon data.
Yeah.
Because we often have a hard time evaluating because we don't collect the data that we need.
That's a very good idea.
And well, the other issue then is if this moves on, and the motion actually would be to re-refer to rules, back to rules for re-referral to appropriations. That we do this under the understanding that this will come back to the committee if those amendments are not taken in a way that we find satisfactory.
Oh, absolutely, Madam Chair. And it's been brought to my attention that if we do a data collection, that will drive up costs and might present an
will.
appropriations problem. So instead of that, if the committee is willing, let's go to the 3 years and report at the end of 3 years where we are. A 3-year sunset.
We don't agree on data. What's going to happen when the other people sitting here are asked to evaluate?
Well, why would the data collection or the reporting back, and it would be to the chair's liking, what would be involved with that reporting, be a county expense, not a state expense? County has to report to the state.
Okay, so if the data is
or-
still being collected, if that's the
specifically to-
concern,
to this
but only for
committee's
3
chair.
years instead of 5, makes it better for appropriate purposes?
Madam Chair, thank you. Great discussion, like the way it's going. I would like to add, though, I think that the 2 concerns that we raised actually fit well within the new framework that's being instructed here. One of those was the additional protections in 19.8 with respect to collateral consequences. I think that would go a long way to ensure that anybody who does make this infraction charging decision absent a right to counsel, which it doesn't seem that we're putting in now, would not suffer the greatest consequences of that decision. And the second piece of it, with respect to Senator Leno's comment about the goal of saving money, is that if somebody did elect to be charged, have their conduct charged as a misdemeanor, and then was told, actually, you would be better off with an infraction, and they're allowed to reduce it, that still goes to the cost savings that we're trying to create here, because while it would be elevated, that attorney can say, very, very quickly, without any formal process, hey, you should go back down to infraction, and that can help us to save the trial that would have come out of that decision. So just like to inject that into the conversation for your consideration before we move on.
So what would an amendment to that effect look like?
I would say something along the lines that if a person charged with an infraction who indicates they want to be charged as a misdemeanor shall immediately be appointed counsel, and that person, after consulting with counsel, may rescind their request that the charge be a misdemeanor without penalty, and the case may again proceed as an infraction.
Could you read that again?
Sure. And this is not final agreed upon. This is just kind of suggested language that if a person charged with an infraction who indicates they want it charged with as a misdemeanor, that person shall immediately be appointed counsel, and that person, after consulting with counsel, may rescind their request to have their conduct charged as a misdemeanor without penalty, and the case may proceed as an infraction. So they would have that right, kick it back down.
I think I've got it. How do you think the unsophisticated defendant would think about doing that. It seems to go back to Senator Monning's
If I
problem.
could make a suggestion, that is maybe something that we could continue to discuss if the initial right to counsel is a hangup. As we've already talked about, current law on infractions doesn't provide right to counsel, but perhaps something to discuss, which would be a bit of a compromise, would be, and I don't know this would elevate the costs, and we should continue to discuss it, but it's simpler than saying it goes up and goes down and reduces and all that kind of stuff, is perhaps providing for counsel at arraignment. And if at that point the person elects to go forward as an infraction and still assert their right to a trial, they don't get the attorney. It goes forward as a normal infraction.
That sounds,
It's a little simpler than
Right.
elevating and reducing and all that kind of stuff.
Well, it sounds like there's an openness to work on this, and maybe one of the agreements that comes out of this is that feature is a component. As the first proposed kind of rough language, it doesn't create a new right. What it says is if you choose the misdemeanor, you're entitled to counsel. Well, that's existing law. If you're charged with a misdemeanor, you're entitled to counsel. And I think the only nuance is that you wouldn't be locked into that after consulting with counsel if counsel said, you know, you're going to be better off if you pursue the path of the infraction. I think the spirit of this proposed amendment is you wouldn't be stopped or blocked after having that contact with counsel. But, you know, I think it would be more economical as proposed because it would only afford counsel to those who choose to pursue the misdemeanor path. Your suggestion from the district attorney was a possible interface with counsel at the time of arraignment, which might be more comprehensive. But could this be something that could be explored? It sounds like there's a shared interest in that evaluation, somebody not being penalized if at the front end they pursue the misdemeanor.
And if at the end of 3 years or 5 years, because I think we do have to specify data. We don't want a lot of data. We just want a few clear indicators of what's going on, really. And I believe that courts have to report now to the Judicial Council or to the AG's office. So I don't think that it should be prohibitively expensive. If we do that, it might turn out, that you could eliminate some of these steps and save even more money. But right now, because we are talking about a very important constitutional right, which is the right of the accused to know what they're up against, right? I think that would be a good idea. Okay. Now, I'm trying to figure out what would be a time when we could call this bill back. We can call it back any time before it goes to the Senate floor, right? Why are you saying no?
Staff is not aware of any mechanism where the committee would receive this bill again from Rules Committee. It would have to be something that the Rules Committee would determine. And once the committee passes it out, unless the bill is significantly amended into the form of a new bill, I'm not aware of a mechanism that would bring it back to this committee.
Well, I don't understand that because we have often said we have the right to call the bill back, and other committees have done it to my bills. I could,
And it has to be off the Senate floor by the end of the meeting. As House of Origin. We're dealing with a select group of bills now in committees.
Madam Chair, if I may, you have my word that we will go forward. You have, I think, both of the opposing witnesses saying that there is an interest in achieving our goals together. In any event, the bill will have to come back to the Senate floor on concurrence down the road, and chair and committee members can all stand in opposition if we don't do what we say we're going to do and explain to the rest of the body that we haven't done what we've committed to. We will do it. And if there's not, because we're in a situation where the bill can't be called back to committee, that would be a horrible reason not to grant the positive relief that this bill will provide. We just need to hammer out a few details, and I think we're very close to doing that.
And Madam Chair, I would also suggest that I don't think any of us believe that the author would actually bring it up on the floor if all this hadn't been resolved.
Okay, just as another question, however, if the bill were not to be passed out today and was introduced as a new bill with the amendments, would it take effect at the same time? I believe it would, next January. Yeah. And that might be a cleaner way to do this. So I understand we've gone through a lot of mishigas here.
You can say that.
Kind of phrase.
Objection.
But I think I see where we want to go. Which is, I understand now that we will retain the existing judicial discretion but not expand it. And that we want to make sure that any environmental or corporate crimes or Cal-OSHA issues are excluded from the bill, and that we want the defendant to have the benefit of counsel before accepting the infraction. And that could be simply meeting someone before arraignment who can say, if you do this, this will happen. If you do that, the other thing will happen. And it shouldn't add significantly to the costs. And that we also would have a sunset. And I'd be happy to have a 5-year sunset with the inclusion of a few specific data points that can tell us if this is successful. Does that seem to meet that would be the intent of the committee?
Madam Chair, the one thing, I think a 3-year sunset is important rather than a 5-year sunset in order to meet the appropriate needs. And that's better really for the Senator Leno's concerns of the shorter sunset to see if it's working or not.
And if there's unintended consequences.
Right, right. Yeah, so
That would be okay.
that was the initial suggestion.
Yeah, so the intent would be that these amendments that will be, are specified in the motion will be taken in the Appropriations Committee. Yeah, okay.
I so move as amended.
Okay.
To
Senator-
be amended in appropriation.
Senator Glazer.
Madam Chair, I know we're finishing up the discussion on this, but I wanted to ask for the record, the sponsor's representative to be clear about the number of cases involved here. She's talking about important consequences of on their budgets and the like and workload, but I'd be interested in hearing clearly how many cases do you think this is going to affect in San Diego, our work today?
I don't know the exact number of cases. I'd have to run data on charges of what's actually charged. I do know from the data that I have seen in San Diego County that we have seen a significant increase in misdemeanor jury trials post Prop 47 that far outweighs the decrease in the number of felony trials post Prop 47, if that makes sense.
But you don't have any idea how many cases this would apply to then? Then how can you assert the kinds of savings and efficiencies that you're suggesting?
I don't know the numbers. I don't know the number of crimes I could run that, but then again, I don't know how many year-to-year crimes are going to occur. But just in the sheer number reduction of trials in court costs would go down. And I think we can further explore the exact data, at least out of San Diego County, but I didn't bring that with me.
Yeah, and I think that we are going to need a data point to really, one of the concerns that I still have that came up during the discussion is the business about whether this becomes a way to save money, raise money, or what. I wish there was a way to reinvest the savings services. And it is also just anecdotally interesting to me that the number of misdemeanor cases is going up in San Diego more than the felony cases are going down.
In trials, in number of cases that are going to trials.
What would the reason for that be? And then drill with that.
Well, because Proposition 47 made those certain felonies misdemeanors, so those are now charged as misdemeanors. And why it has increased the number of trials anecdotally, I don't know. I don't know if it's just because the potential penalty is lower that people say, well, I might as well just take my chances at a jury trial. I don't know. Since I'm not a defense attorney, I don't know what those conversations are with the offenders.
I was talking to, in Los Angeles County, we see a lot of the same things. That, you know, when these were felonies, most of these defendants were offered some form of drug court, whether it's Proposition 36, drug court, and so that the defendants would plea to the felony in order to go to drug court because then their felony conviction could be erased. However, as a misdemeanor, and for example, in Los Angeles County, you just kind of roll the dice. If you get convicted and you're sentenced to 90 days or 120 days or less, because of our jail situation, that means you would show up at the jail and go home. And so there is no incarceration.
Why does it mean that? Why does it mean you serve 120 days?
Because of the amount of overcrowding we have in our jail, our sheriff has said that if you have,
So, yeah, right. So
Right.
it gets down to the jail management issue, how many people are awaiting trial, blah, blah, blah. Yeah.
Right, but that's why-
another issue, thank you.
but that's why you see the increase in the
Oh, yeah.
misdemeanor trials.
Okay, good, thank you for that. Okay, there is a motion on the floor, and we would expect that this will be, these amendments will be agreed on by all parties, and that the motion is to refer to the Rules Committee for re-referral to appropriations. Please call the roll.
Hancock.
Aye.
Hancock, aye. Anderson. Glazer. Aye. Glazer, aye. Leno.
Aye.
Leno, aye. Lou. Monning. Oh, sorry. Aye. Lou, aye. Monning. Aye. Monning, aye. Stone. No. Stone, no.
Thank you all. The vote is 5-1. Thank you.
I do that. How am I supposed to let you know I want to speak?
Somebody know.
Oh, okay.
Meeting's adjourned.
Oh, okay.